You are a Berklee faculty member. You have always wondered, who owns the copyright to your work?
See the previous video for some cut and dried examples. Here's one that requires a bit more head scratching. You wrote an article based on your research for a class you teach. You get it published in an academic journal. A publisher wants to license your article for a book. Does Berklee have any claim to ownership of the copyright?
Hang on. This is where we get into the on the one hand, on the other hand kind of stuff that lawyers just love. If the laws were too clear, they'd be out of a job.
So on one side, you have a Supreme Court decision which defines work for hire as something done by an employee rather than an independent contractor.
Berklee faculty are clearly employees of Berklee. A work made for hire is a work prepared by an employee that arguably is within the scope of his or her employment. And who owns the copyright of a work for hire? The employer. Score 1 point for Berklee.
But under the tradition of academic freedom, which states that colleges should not control the expression of ideas,
and a line of copyright decisions that state certain faculty IP is outside of the work-for-hire doctrine,
most faculty members are granted ownership rights to various works created in the scope of their employment.
In 1988, the Seventh Circuit Court endorsed the ancient tradition of the teacher exception.
It said changing it would wreak havoc in the settled practices of academic institutions.
There is a lack of fit between the policy of the work-for-hire doctrine and the conditions of academic production.
And there is no indication that Congress meant to abolish the exception.
Because little case law from other circuits exists on this issue, this explanation is essentially the law.
Think about it. If employers owned copyright to all faculty works, they could censor and forbid dissemination of the work altogether.
Such powers are deeply inconsistent with the fundamental principles of academic freedom.
Faculty are expected to pursue the truth as part of our job. Whose truth? The employer's truth? No, the truth.
Another thing to remember is this. Does Berklee want to be held responsible for opinions expressed in a teacher's work? Does Berklee want to be liable for any damages resulting from the creation of that work? Probably not.
Another good reason that work for hire doesn't fit in a college setting.
A number of these cases were decided under the 1909 version of the Copyright Act.
The revisions to the Act since then have not clarified the issue of the extent to which faculty have independent ownership rights in their IP.
Some experts believe that it is an open question whether the newer amendments to the Act abolish this academic exception to work for hire.
So back to the question about the article you wrote. Does Berklee have any claim to ownership of the copyright?
Well, in the past, Berklee has followed academic tradition and not attempted to assert ownership of faculty work. So,
probably not. But who wants to go through a fight in the courts to find out the answer?
Is there anything we can do to clear this up?
Yes. Unions are in the best position to protect the intellectual property rights of higher education faculty, either through collective bargaining contracts or through negotiation over institutional policies.
The union may clarify ownership rights in a legally enforceable agreement with the administration.
A number of our peers at other colleges and universities have agreements that protect faculty ownership over its intellectual property.
So, your best bet is to be ready to exercise your rights as a union member, to press the college to agree to an intellectual property agreement that is fair to teachers.
Make sure you are signed up for our email list for future developments.
This stuff ain't easy. Thanks for sticking with this video to the bitter end.
Remember what Mark Twain said? Only one thing is impossible for God, to find any sense in any copyright law on the planet.